Tēnā koutou e te tribunal ne ngā roia hoki. I am a retired Professor of Law from the University of Auckland. You will have seen from the 3 affidavits that I have presented to the tribunal, I've set out my various qualifications in relation to the matters that my evidence covers, which include 35 years of expert work on international trade and investment agreements, which relates not only to academic work and analysis, but to advising governments, participating in reform processes, as well as engagement outside government in trying to educate people about the implications of these agreements. The second area of my expertise in relation to Te Tiriti o Waitangi dates back to 1979 when I first joined the faculty. And so I've written extensively on Te Tiriti over that period of time, given evidence to a number of Waitangi tribunals, including in relation to several of the matters that are in my evidence here. And I should say that the first affidavit and the third affidavit are long, and there are lots of attachments. The reason for that is that, in particular, because when I was the claimants expert in the Y2522 inquiry on the Trans-Pacific Partnership Agreement, it was clear that the tribunal itself struggled rather with the alien world of international trade and investment agreements. And so I tried to provide enough context there for the tribunal to understand the climate change specific elements that I'm addressing in my evidence.
Before you commence at your speaking notes, you've read the rules relating to expert witnesses, and you've affirmed in your affidavits that you've prepared this evidence in accordance with those obligations. Is that correct, Professor Kelsey?
That's correct. I have performed that role on a number of occasions in previous Waitangi tribunals and have pursued that same independent approach here.
Would you like, as you present, to have the PowerPoint up now, or as I've suggested, or would you like to read first and then go through at that point?
I think if it would be all right with counsel and the tribunal, I would like to talk more to the PowerPoint and draw on elements that are in my speaking notes rather than read my speaking notes.
Ka pai, Professor Kelsey.
So my friend from the tribunal, I'm in your hands now. Thank you.
Thank you. Well, we can move to the second slide. The tribunal's statement of issues is potentially quite wide-ranging. My evidence in particular addresses issue 3 of the statement of issues. Has the Crown's conduct, including its actions and omissions in response to climate change, been consistent with Tiriti Treaty principles? And the principles that I have focused on are the principles of rangatiratanga, kāwanatanga, mutual recognition and respect, and active protection. And so I will refer to those as I go through the issues. Next slide, please. So the statement of claim from Ngā Toki Whakarururanga is concerned to create the connection between what happens in the international domain and what happens in domestic policies in relation to the climate crisis and treaty-compliant approaches by the Crown to that crisis. And so that connection is deeply relevant to this inquiry. A number of other witnesses, in particular Professor Barge, India Logan Riley, Alison Cole, have talked about the international climate change agreements and the space in which Māori have sought with relatively little success to be able to exercise rangatiratanga. The allied area that I want to focus on is perhaps less obvious because it's dealing with trade and investment treaties, but is in many ways more potent because those agreements are, to a large degree, binding and enforceable and have consequences in the domestic domain, not only legal liability or international law obligations and then legal liabilities that attach to them, but can also therefore directly influence domestic policies in relation to both climate change and te tiriti, and in this case, te tiriti compliant approaches to climate change. And a second element that makes this more significant in a legal sense is, and I'll come to this later in my presentation, that these negotiations are generally conducted in secret. Unlike what occurs in the international climate space or in the UN Declaration on Rights of Indigenous Peoples and other UN processes, where part of those negotiations may occur in private, if you like, between states, the process is generally more open. When we're dealing with the trade and investment negotiations, those are a closed space, which makes it much more difficult for Māori to be able to have effective influence over what the Crown does, no seat at the table, but also often not even finding out what has been negotiated or agreed to until the negotiations are concluded and signed. And so I've given that preface there to try to explain why this, from the perspective of those who monitor this process, why that is a really significant and relevant matter to this inquiry. So my evidence, as Council indicated, covers three aspects, and I'll come to those in the next slide. But when I went to the statement of claim from Ngā Toki Whakarururanga, I wanted to highlight in particular three elements of that my evidence addresses. The first is the failure of the Crown to take adequate steps to mitigate, adapt to and address climate change through these agreements. The second is the Crown's failure to support the authority of Māori to mitigate climate change. And the third is the failure to partner with Māori to enable tikanga and te ao Māori perspectives to assist in the discharge of Aotearoa's international obligations to prevent and mitigate the effect of climate change. So as Council in his openings identified, I am going to focus on three matters. The first being the authority to make international treaties being an intrinsic element of rangatiratanga, including the making of international trade and investment treaties that relate to the climate crisis. So the rangatiratanga argument. The second is a conceptual argument that international trade treaties embody a Western capitalist worldview and associated solutions to the climate crisis that are antithetical to tikanga and fail to actively protect Māori in terms of te tiriti o Waitangi. And the third point, or the third matter, is that adopting climate measures that are treaty compliant and recognise mana whenua are at serious risk, in particular from what we call investor-state dispute settlement in international investment treaties. Next slide, please. So rangatiratanga in treaty making is a matter that is often not part of the standard debate around rangatiratanga. Often the debate on rangatiratanga is limited to the domestic domain and the exercise of constitutional authority within the boundaries, the territorial boundaries of the state of Aotearoa, New Zealand. But of course, rangatiratanga is an intrinsic authority that is not predetermined by its territorial space. It's determined by the authority and mana of those who exercise the power or authority to treat. And in my evidence, I refer to work that Mona Jackson, the late Dr. Mona Jackson, had prepared in a number of Waitangi Tribunal inquiries, Te Rohi Potai, Paparahi o Taraki, as well as Y262 TPPA, explicitly addressing the power to treat, the power of polities, of hapu-based polities to make arrangements or treaties or pacts with each other. One such polity obviously being with the Crown under Te Tiriti o Waitangi. And Mona's argument, and we discussed this on many occasions, is that because that power to treat is intrinsic to the mana of the rangatira in exercising their responsibilities to their hapu, it is not something that they would or could cede to another entity. Yet, Kāwanatanga claims that it has exclusive Crown prerogative to enter into international treaties with no right of Māori to have any seat at the table under some assumption of Crown sovereignty. Now, that issue is going to be addressed in its constitutional dimension before the Constitutional Kaupapa inquiry. But as we've seen from the evidence in relation to power and process already from a number of the witnesses in the climate change inquiry, it's the conduct and operationalising of that Crown prerogative is fundamental to understanding whether there has been a breach of the principle of rangatiratanga and whether there has been an exceeding of the authority of Kāwanatanga in the international treaty space as it relates to the climate crisis. And so I would refer the tribunal to the evidence of India Logan Riley, the evidence of Alison Cole, the evidence of Professor Barge, making it clear that the way that these processes have been working, everything is mediated through the Crown. Access to information, rights to participate in discussions, seat at the table, the ability to voice and advocate for tikanga-based approaches, for mātauranga, for kaitiakitanga and the protection of te kaio, to raise issues and concerns about the approaches that are being taken, even in initiatives that are supposed to be protective and advantageous to Indigenous peoples. They have talked about that predominantly in the space of international treaty making on climate. The same applies when we are dealing with international trade and investment treaties as they relate to the climate crisis and as they relate to Indigenous peoples and the interface between the two. That is a concern that has been raised in many different forums in the past. It was raised in Y262 in relation to the treaty-making processes because international trade treaties were a part of the Y262, in particular the WTO's agreement on intellectual property rights. And the Y262 tribunal raised concerns especially about a 2001 Crown strategy for engagement with Māori on international treaties. The Trade for All Advisory Board that was established after the TPPA raised issues again about rights of Māori participation in the international treaty-making process, including proposals regarding rights to a seat at the table and rights, in fact, to act as advocates in matters of importance to Māori. And then the issue came up again in Y2522, especially in relation again to this 2001 Crown strategy on engagement on international treaty making. So this is not a new issue, and it's been raised in various different specific contexts. As part of some research that I was doing, I came across a reference to there being a review of the international treaty making process as a follow-up to both the Trade for All Advisory Board report and recommendations and Y262 as part of Te Pai Tawhiti that Minister Mahuta had set up, and then the Y2522 as well. And so I made some Official Information Act requests and received a kind of drip feed of documentation, which I'm currently putting into a narrative form because it covers the period 2021 to 2023, where there was within MFAT and TPK and some other Crown agencies and the Minister work that was done on how to change this international treaty-making process, including participation of Māori in delegations and the ability to exercise more influence over the process. It was interesting that the direction of the review was explicitly reduced to incremental and pragmatic changes to the current approach of not questioning Crown prerogative to make treaties, explicitly to avoid having to address what was seen as the tricky constitutional questions around rangatiratanga and treaty making. And it was acknowledged that many Māori would feel that this was short of the Crown's obligations under Te Tiriti. What then happened was that there was a cabinet document that was signed off by Minister Mahuta, but which was never presented to cabinet. I understand because of concerns relating to the backlash on He Puapua and on Three Waters and so on. And so as a consequence, not even that incremental pragmatic approach that the Crown itself was discussing internally has changed. And we're still back at that 2001 engagement strategy with Māori, which is basically if a Crown agency thinks it's an issue, it then decides how serious the issue is and what level of engagement is required. Hence, as we've seen from the narratives in relation to process from Ms. Logan Riley, Ms. Cole, and Professor Barge in the climate space, but also in relation to my own evidence in relation to trade and investment treaties, there is without doubt a breach of the principle of rangatiratanga, an exceeding of the authority of kāwanatanga, and a failure of active protection, including active protection of the right to exercise mana in the international space. And I might just note finally on that point that previous tribunals, when they've actually referred to the Crown's role in the international space, have referred to it as in a kind of contingent way, but in relation to foreign policy, not in relation to these kinds of agreements that have such direct domestic impacts. Do I have the next slide, please? So moving on to the agreements themselves in relation to climate change. As I indicated in my affidavits, I've worked in the area of trade agreements since 1990. And it's very noticeable that for the vast bulk of that time, climate change was not an issue. Even the environment was not an issue for much of that period. But as climate change became more of an issue, as we had Kyoto and then Paris agreements, the question of the interface between those agreements became more important. But in the trade agreement space, the primary interest is advancing commercial interests. And so in addressing the climate crisis, there were two visible elements. One was to promote commercial benefits, and the second was to avoid obligations to alter practices that were being challenged as harmful, especially in terms of emissions. And then what we started to see in the agreements, and I saw this first in the CPTPP, but it certainly expanded as this has evolved in later agreements. We saw the climate crisis referred to through euphemisms. So we had low emissions economy or green economy or blue economy or green investment, and then the use of market mechanisms such as carbon offsets and tradings and CCUs. And so this has become more common in recent agreements, and some agreements even are explicitly purporting to address the climate crisis, but through those mechanisms, which are effectively mechanisms that seek to neutralize or cancel out environmental harms rather than actually reducing emissions. Sometimes, however, they are also opportunist of purporting to address the climate crisis while actually seeking to advance other trade objectives. So I've referred to a number of them in my affidavits. I just want to refer briefly to three of them here. A recent one is the agreement on climate change, trade and sustainability. So one would expect this to be directly engaging with climate change. It has 4 pillars, 2 of which are actually about removing tariffs on a whole long list of goods that are deemed to be environment and climate related goods, and a whole long list of services likewise, which include things like engineering and consulting services and so on. These are actually activities that have been pursued in the WTO with no progress for a couple of decades, and this agreement has become a mechanism for advancing that. There is an attempt to phase out harmful fossil fuel subsidies, but are defined in terms that would, for example, not address the expansion of effective subsidies to New Zealand high power use producers, as we've seen recently. And it's very, very weak. And the fourth is voluntary eco-labelling. So we're seeing climate change being used as a Trojan horse for other objectives, and indeed the minister's announcement on it said this is going to help us export more forestry products, etc. New Zealand has taken the lead in this. New Zealand, Singapore and Chile. The Indo-Pacific Economic Framework advanced by the US, the supply chain and clean economy agreements advance the kind of extractive, green extractivism that Professor Barge referred to, and is all about market and technological solutions, and I'll refer to the critical minerals dialogue again shortly. One that has gone further is the EU-New Zealand FTA, which, consistent with EU domestic policies and concerns that its producers are at a disadvantage because of its climate policies, it makes the Paris Agreement NDCs enforceable. However, the language is very ambiguous, and it's adjudged by my colleagues in Brussels as being very unlikely that the US would actually take enforcement action on it. And I note in my evidence that when this advice was put to Minister Jones in relation to some of his policies that were to reduce environmental, etc., protections to attract mining and other fossil fuel companies, he just shrugged off the advice. So my point about these agreements is that they are in many ways rhetorical, but actually seek not to address the kinds of practices that are engaged in by states involving those treaties, involved in those treaties, including New Zealand, but to advance their own interests through that. Can I have the next slide, please? There have, of course, been a lot of criticisms about this. And what we've seen in recent agreements is rhetorical references to sustainability and inclusion, especially of Indigenous peoples, as a way of trying to counter the criticism that this is really an attempt to bypass taking real action whilst promoting forms of green extractionism. And the example that I'm giving here, because it links to the next specific case study, is that the IPEF Clean Economy and Supply Chain Agreements, which were concluded just in the last couple of years, include 9 references to Indigenous peoples. And this was referred to in the national interest analyses when the treaties were tabled in Parliament, making it look like this was something that was going to engage with Māori, but also benefit Māori, as well as other Indigenous peoples, who, of course, had no role in the negotiations, except Ngā Toki Whakarururanga did on a purely confidential, secretive basis, having input which had relatively little effective influence. So the 9 references include a recognition of Indigenous worldviews, of the important role of Indigenous peoples in transition to clean economies, the intention to partner with Indigenous peoples, drawing on traditional knowledge and practices. But this is all in the fluff part of the agreement. It's in the preambles or in the non-operative parts of the agreement. The substantive parts of IPEF reflect none of those factors. They're all back in that old Western capitalist, technological, financialized, commodified model. Nor is it reflected in the implementation of those agreements. If I could have the next slide, please. The example I want to use is the critical minerals dialogue. Now, critical minerals are an essential part of the new green technologies that are supposed to provide substitutes for the old fossil fuels and high emissions forms of resource extraction, production, investment, etc. And of course, the search for those has become more and more important, and you, Tribunal, will have noted, for example, that it is seen as a very significant factor behind the current US administration's moves in relation to Greenland and Ukraine and so on. The critical minerals dialogue is aligned to those two IPEF agreements I just referred to that talked all about Indigenous peoples, worldviews, importance of their knowledge, participation, etc. There is a work program that was established under the IPEF agreements, and MFAT is responsible for IPEF, but IMBI has been responsible for this critical minerals dialogue that is a part of the IPEF work program. And I must say, I only found out about this not because wearing an advisor to Ngā Toki Whakaruriranga's hat that was raised there, but because I read about it in some other documents. So what became apparent was that in a mixture of domestic processes and this IPEF process, IMBI has been mapping mineral reserves, resources and processing capacity in Aotearoa. And there was a call that was held with IMBI and MFAT once this issue was raised to say, well, where is the Māori participation in this that was promised in terms of IPEF? Where are the Indigenous worldviews in this? Where is the recognition of the role of Indigenous peoples in transitions to clean economies? And it became clear that there even being a Treaty o Waitangi element to this had not occurred to the officials who were addressing this. There was no IPEF Indigenous partnership or participation. There wasn't even an alert that this was happening. Now, this is not a criticism of the officials. This is a systemic problem, because when we have been looking at these issues in the international trade space, it's become clear that there is a commercial, investment, economic and geopolitical agenda behind how the climate crisis is dealt with, and other references are basically greenwashing, nature washing, Indigenous washing and so on. The response that came from officials about the mapping exercise was, oh, well, this is just a technical exercise in mapping, and there's room for that kind of participation subsequently. To which the response, I think it was India Logan Riley on this call with the officials, was, Well, that's what they said about survey pegs in the 19th century. That this is clearly an intention to engage in extractivism of the kind that Professor Barge was talking about, without there being any free, prior, informed consent, without being any involvement or authority by Indigenous peoples, but also adopting a model that is antithetical to those that Indigenous peoples would bring to a climate crisis. Next slide, please.
Can I ask, before we go to the next slide, I'm reading in the microbreak, I read from your speaking notes from paragraph 16 to paragraph 19. Could you just elaborate a little bit about the concept of nature-based solutions and how they had deeply problematic implications, which you discussed in passing in this slide, but spoke more deliberately about in your notes, your speaking notes, please?
Certainly, Ms. Sykes. The critique of notions such as nature-based solutions and blue carbon and carbon sinks and carbon capture, utilisation and storage, CCUS, are addressed, I think, really well in a number of the submissions from others who have climate expertise. If I could just refer to a couple of those to assist the tribunal. Alison Cole's affidavit talked in terms that I referred to a little earlier about how things like offsets and market approaches and financialized approaches to emissions, such as trading systems and so on, are a means of avoidance of actually having to address the actual causes of climate crisis and often lack integrity. Carbon and carbon sinks and carbon capture, utilisation and storage, CCUS, are addressed, I think, really well in a number of the submissions from others who have climate expertise. If I could just refer to a couple of those to assist the tribunal. Alison Cole's affidavit talked in terms that I referred to a little earlier about how things like offsets and market approaches and financialized approaches to emissions, such as trading systems and so on, are a means of avoidance of actually having to address the actual causes of climate crisis. And often lack integrity, something that India Logan Riley raised as well. In her paper that's attached to her affidavit, India Logan Riley talks in particular about nature-based solutions and blue carbon as being a kind of commodified logic that treats the climate crisis not in a holistic sense to which there need to be holistic solutions in the way that that would be approached by Te Ao Māori, but seeks mechanisms or instruments that, again, do not address the real causes. They suggest that you can somehow cancel out the impacts of bad practices by these instruments that commodify, for example, subsea, sub-ocean plants and corals and so on that might absorb and hold carbon. And she makes a point, and I've seen this up near where I live at Pakiri, that the consequences often of those offshore processes, such as mining or dredging or whatever, are actually to erode the nature-based options that are intrinsic to nature, such as the sand dunes and the vegetation, that can act as proper absorptions. So by fragmenting and commodifying, there is not actually a picture of the whole. Emily Bailey's evidence in relation to Taranaki raises some more of these nature-based approaches and seeking to find alternative mechanisms that are in themselves destructive of te kaio, such as hydrogen economies. She used the example of the wind turbines, which are basically commercial ventures that have no real commitment to addressing the climate crisis. No free prior informed consent, but often actually displace Indigenous peoples, not just from the whenua or from the moana, but from the ability to exercise mana whenua and mana moana. And that, of course, all comes together in what Maria Barge refers to as the new phase of colonisation through green extractionism. So it's that kind of critique that underpins the reason why those solutions that are put forward in those agreements are seen as antithetical to a te ao Māori approach, but also to the exercise of rangatiratanga, mana motuhake, kaitiakitanga, etc. Does that answer the question?
More than adequately, thank you. Can you go to the next slide, please?
So the third element that I wanted to discuss is what I see actually as the most immediately potent threat to a treaty-based, treaty-compliant approach to the climate crisis in Aotearoa. And that is through the right of foreign investors to directly enforce special protections that are given to them in either bilateral investment treaties that only deal with investment or in the investment chapters of free trade agreements. We are fortunate here in that we only have 2 of those bilateral investment treaties. They date back to the 1990s, which was the time when UNCTAD talks about these being really problematic because they're very crude, blunt instruments that give foreign investors very extensive protections and have virtually no exceptions or other mechanisms that might mitigate their impact. And the 2 that we have are with Hong Kong, China, and China. Then we have investment chapters in a number of investment agreements, trade agreements. And those include with countries like Japan, Canada, South Korea, Indonesia, Singapore, Mexico, who are big investors, including in the fossil fuels area. And there are a couple of really important things about these investment agreements. And I outlined in my first affidavit why these have become so controversial. And I'll just very briefly touch on the bullet points of that. I mean, they give very extensive special protections that don't exist in domestic law to foreign investors, but they are very vaguely worded. They don't have any corresponding obligations on the investors that can trade off against them in almost all the agreements. And these interpretations of these open-ended rules are done in ad hoc arbitral tribunals established under those agreements, which are offshore tribunals that have no system of precedent, have no appeal structure. The arbitrators are, unfortunately, renowned for having conflicts of interest, of acting as counsel in some cases and judges in other cases. They have varying and unpredictable interpretations of various rules, but which are usually pro-investor. They can award damages that are not only damages for what the investor has invested to date, but for lost future profits for the entire period of the projected investment with compound interest, and we'll see the consequences of that shortly. But also these often take place in secret. In some cases, we talk about the number of known disputes because many agreements don't require disclosure that there is even a dispute, let alone of the documentation or the outcome or the amount of an award. Now that has changed a bit in more recent agreements, but it remains very variable and very problematic. This was a big issue during the TPPA. And as a consequence of that, the Labour New Zealand First government, when it came in 2017, said, we will not have investor-state dispute settlement in any future agreements. And to give them credit, and the current government, which has continued that policy, there has not been ISDS in new agreements. And that's because of the potential legal and fiscal risk of policies that governments take that investors say impact negatively on the value and profitability of their investment, but also the internalized concerns that officials have in giving advice, what we call the chilling effect, that I'll refer to a bit later. But we still have many agreements with ISDS, including one that was just renewed recently with all the ASEAN countries that includes ISDS. This is of real significance in the climate change area because UNCTAD, which is the entity that is largely oversees these agreements, its data shows the rising use of investor-state dispute settlement by investors to challenge climate measures. In some research that I quote in my first affidavit by Nicolas Perrone from Chile, research that's been done on Indigenous peoples in ISDS cases, which largely involve environment and most recently climate. It's Indigenous peoples' resources that are generally those that are involved in these disputes. Yet Indigenous peoples have no power in these disputes because the state operates the defence, and even the possibilities of amicus curiae briefs are in the hands of the arbitrators and very limited. And so this has become a major concern in the discussions around ISDS and Indigenous people's resistances to that. XL Pipeline in the US is a clear example of that, and when Indigenous people succeed in shutting something down, that in itself can end up being subject to an investment dispute because the state has allowed that to happen. The UN rapporteurs are predicting that fulfilling Paris obligations are likely to result in $340 billion US liability in ISDS disputes. So what we're seeing is that even countries that were strong advocates of ISDS are now quitting agreements because of claims in relation to climate change. The European Union and a number of its member states in particular have done so recently. So the question is, where does this leave New Zealand with its existing agreements, its bilateral agreements with Hong Kong and China and the investment chapters in other agreements? Because there are relatively minimal protections. There are none effectively in the China and Hong Kong agreements and minimal in the investor-state disputes mechanisms in the other agreements where the interpretations even of the 2001 Treaty of Waitangi exception would be quite random. And we had a lot of discussions on that in the first 2522 inquiry of Amakura, Kāwharu, myself and Penny Ridings, all reaching different conclusions along a spectrum that there were significant potential issues with the treaty exception in relation to CPTPP. Next slide, please. So I just want to give you two examples to show that this is not just hypothetical. One of the issues when this was first raised in the water claims some years ago, and then in the urgency hearing on Y2522 TPPA, was that yes, there were risks, but what would happen was speculative. Well, we're now seeing enough evidence to show that there are smoking guns. One that has become very notorious, I would even say, in Australia and here involves the case of an Australian mining magnate, Clive Palmer, who is actually suing his own government through the back door of a Singapore company under ISDS for matters that he failed at in the domestic courts that relate to environment and climate-related measures. Now, Clive Palmer is a particularly colourful person. His Who's Who lists litigation as one of his pastimes. He funded the advertising campaign to oppose the voice referendum in Australia. He uses what we call slap writs to get environmental NGOs to back off because they can't afford to conduct the litigation. And so he is someone who is predisposed to such actions. Because suing his own government couldn't be done by his Australian company, Mineralogy, he then engaged in what we call forum shopping. Firstly, he reincorporated Mineralogy in New Zealand and announced he was going to sue Australia under ISDS from New Zealand agreements, but his lawyers obviously did not do a very good job of advising him because Australia is one of the few that we have an ongoing agreement with not to allow ISDS to be used. So he then took Mineralogy off to Singapore in 2019. He has now brought 4 disputes that we know of against Australia over mining, environment and climate measures, which include court decisions, not just laws, and the total of his 4 claims against Australia are $420 billion. 3 of those claims are under the ASEAN Australia-New Zealand FTA, to which Australia and Singapore are parties, and so is New Zealand. And that is the one that was just renewed last year with ISDS. So Clive Palmer uses ISDS, he weaponizes ISDS as a mechanism to deter governments or punish governments if they adopt climate-related measures that are adverse to the interests of its mining companies, which include rare earths, critical minerals, and so on, not just fossil fuels. Mineralogy is incorporated in New Zealand. There is a chart in my 3rd affidavit showing the exploration and prospecting applications that they had made, a number of which drew protest from mana whenua. I learnt recently through Radio New Zealand that he had withdrawn all but one of those because he said he was refocusing investment elsewhere, but the one he still has is 19,000 hectares in the Waikato Whakarururanga area for exploration permits that include rare minerals such as lithium. What we should expect is that if there are moves on that or any future applications that he makes by a government to shut down or not renew those permits, I think his current one is a 5-year one for Waikato Whakarururanga, then he will threaten and potentially bring an investment dispute. Next slide, please, which is my last substantive slide. I mentioned before that the threat of losing a case isn't the only concern about investor-state dispute settlement. A much more common concern now is what we refer to as the chilling effect of not just an actual threat of investor-state dispute settlement, which, for example, occurred in relation to plain packaging of tobacco, where Philip Morris threatened to bring a dispute, had one against Australia. New Zealand held off until that was resolved. But the internalisation of legal and fiscal risk into the advice that officials give on the adoption of new policies and laws. And this has been discussed in a number of tribunals previously, the Water Tribunal, the 2522 TPPA. In the water one, it was treated as the Crown said, oh, we promise we won't be chilled. When it came to the TPPA, initially the tribunal said the risk was speculative, but then in the final stage 3 inquiry dealing with the digital, there was a much deeper discussion, and the tribunal said, yes, we actually recognise that this is a significant risk. Nevertheless, we didn't have the smoking gun, and the question is whether we now have the smoking gun that shows in the climate context how this might play out, reinforcing the concerns that I just raised about Clive Palmer. When the previous government introduced a ban on offshore oil and gas permits off Taranaki in 2018, it only applied that to new permits. And that surprised some of us. But then I came across an article, and then a more recent article in The Guardian that quoted James Shaw as Minister of Climate Change, saying that the reason it didn't apply to existing permits was because of advice that there could be an investor-state dispute over interfering with the existing permits. So I then set about doing a little bit of detective work and discovered that the advice was actually primarily to Minister Megan Woods, the Energy and Resource Minister, but also then to James Shaw as Climate Change, not to apply the ban to existing permits. And so the OIA responses that I received under urgency from IMBI, requested a number of agencies, but it turned out to be IMBI that was responsible. They very helpfully sent me a number of documents that had already been made public, one of which was a cabinet memo, but another was a specific paper dealing with existing permit holders. And that document has extensive pages redacted of legal advice in relation to applying the ban to existing permit holders. And I asked MB if they would reconsider that in light of the years that have passed, and yesterday afternoon they sent me a message saying no, they wouldn't. They wouldn't waive legal privilege on this. I think it's a reasonably strong presumption that that legal advice applies to ISDS, especially because there is a reference elsewhere in the paper to so-called sovereign risk, and they would have been the two main legal issues, I would have thought. So I think we've moved beyond the merely speculative to the very likely risk that ISDS has already chilled decision-making related to the climate crisis, and that there is a very real and present possibility that Mr. Palmer could bring an investment dispute either relating to his existing or future investments here, were he to be aggrieved about either mana whenua action or decisions of the Crown, a regional authority, or some judicial process. So if I could have the last slide, thanks. So my recommendations as a result of this analysis is that the tribunal firstly recognises, as other witnesses have said, that the Crown's approach to climate change, as reflected in these FTAs, reflects Western values and commercial priorities and excludes mana motuhake and te ao Māori, as well as the responsibilities, duties, rights and interests associated with that. That ISDS remains a major risk despite the cross-party post-2007 policy position, and that the tribunal needs to act as a treaty circuit breaker on a reluctant Crown in terms of process, rangatiratanga, seat at the table of decisions, including stressing the need to address those outstanding issues in the context of climate change, both in the international climate sphere, but also in the international trade and investment sphere as they impact on climate. Secondly, that there needs to be a treaty circuit breaker in terms of the concepts that the Crown uses, not simply referring to te ao Māori and mātauranga and kaitiakitanga and tikanga in as kind of dressing for business as usual, but that it actually takes those seriously and empowers those concepts and Māori to implement them. That the Crown stops signing up to agreements that exacerbate the climate crisis, and that it withdraws from starting with the bilateral investment treaties with China and Hong Kong, which it can withdraw from much more easily than the FTAs, but that it initiates a review of ISDS that provides it with more leverage to go back to other countries saying, this is our mandate and we have no mandate to continue to agree to ISDS. And I note that New Zealand First has previously even sponsored legislation around ISDS. And finally, that there is a finding that active protection responsibilities, or the active protection principle, applies not only to concepts and actions by Māori, but to the actual authority of Māori in terms of mana Māori motuhake and te tiriti o Waitangi. So that is my evidence. I hope I didn't lose the tribunal too much into the weeds of this rather arcane space of trade and investment agreements.